countries which have high price for that pharmaceutical product. So it may lead to an impact where essential medicine, the supply of that essential medicine could get depleted. Moving on to exhaustion of patent rights under the statute, which is Patents Act. I think this has already been briefly alluded to by Mr. Hemant Singh. The relevant provision is 107AB of the Patents Act. And I just wanted to point out the difference between the language which was there in the 2002 amendment as compared to the 2005 amendment. And I think if we compare these two languages, I think it becomes absolutely clear that under the patent statute at least, India definitely has an international exhaustion principle. So 107B, AB of the Patents Act 1970, when the amendment was introduced by the 2002 Act, it says importation of patented products by any person from a person who is duly authorized by the patentee. And therefore, it talked of a situation where it's a patentee's licensee or an authorized distributor. Whereas the language which now exists after the 2005 Amendment Act, it talks about by any person from a person who is duly authorized under the law to produce and sell or distribute the product. Now, it's again, there is no clarity on what does duly authorized under the law and which law are we talking about. Most probably, and the most reasonable interpretation would be the law of the country of export. But these are some of the uncertainties in the patent statute, and because of the dearth of case laws, really, which have interpreted these terms. But because of this amendment in 2005, I think it is more reasonable to interpret that India follows the International Exhaustion under Patents Act. Exhaustion of trademark rights. Again, this topic has been extensively dealt with. I think the key issue here is that when Section 29(1) and Section 29(6), when it is interpreted and read along with Section 30, subclause 3 and 4, a lot of things are not very clear in terms of what is the market being talked about. Is it the local market or the international market? Also, what is not clear is what do you really mean? So moving on to the next slide, what do you really mean by legitimate reasons to oppose? Now, even if we assume for a minute that trademark statute follows the international exhaustion principle as was held by the division bench in Kapil Wadhwa case, it still doesn't mean that the parallel importer has a free hand, because if there are legitimate reasons which are available to the trademark owner to oppose such parallel importation, or if the condition of those goods has been impaired or changed, then they will still constitute infringement. Also, another thing which needs to be taken into consideration is a lot of these goods which are parallel imported, they will obviously not comply with the local packaging laws and labeling laws. So, for example, the Legal Metrology Act in India, and therefore a cause of action could also be available under the Legal Metrology Act. Either suo motu, the authorities can file a complaint, or the brand owner can file a complaint to the authority under the Legal Metrology Act for violation of packaging laws. These are some of the cases which I'm going to briefly deal with. These are all cases in India under the trademark statute. I think what they tend to show is the fact that throughout the years since 2000, there has been a complete uncertainty in terms of how the courts have interpreted Section 29 and Section 30. And it shows a picture where the courts are not unanimous, up till now at least, in the holding of whether the trademark statute in India follows international exhaustion or domestic exhaustion. So, for example, in Hindustan Lever versus Briju Chhabra case, this was about importation of soaps, and these imported soaps were for sale in Indonesia only, but they were now sold in India without the consent or permission from the plaintiff. And the defendant was held liable for trademark infringement. Moving on to the Xerox Corporation. In that case, again, there were import of second-hand printers and second-hand Xerox machines rather, with proper documentation, which were imported into India. There was no change or impairment in the condition of that good. And in that case, the defendant was not held liable for trademark infringement. Kapil Wadhwa case we have already dealt with in detail. The Western Digital Technologies case, 2016, I think here, this is another interesting case because this is a case where the plaintiff manufactured computer hardware, the defendant was importing plaintiff's products and selling it into India. The primary allegation of the plaintiff really was that these imports were not legitimate and these goods were not procured in a lawful manner. However, it appears that this matter was ultimately settled, and as part of the settlement order, what the judge directed parties to do, or the defendant to do, is to affix a label on the products indicating that the products were imported and were not valid for any warranty claims. INTA submissions in the amicus brief filed in Samsung Electronics versus Kapil Wadhwa, I think this also we have dealt with. I'm going to move away from this. And this is the last part of my presentation really, which talks about the various mechanisms which could be utilized to tackle the adverse effect of parallel imports. Some of this is original thinking. A lot of it is actually based on articles and research papers written by leading economists, which I have cited towards the end in the bibliographic section. So I think one of the measures which could be adopted is coordination of pricing decisions at the central level or through informal coordination between the various branch offices of that multinational company. I think what this would do is you try and create a price mechanism whereby there is not too much of a differential between the commodity as priced in Europe, for example, or as priced in Southeast Asia and India. This could be one of the effective way of tackling parallel importation. The other example which I have dealt with here is creative merchandising by introducing product plans that create intangible product differentiation, or, for example, giving special financing models, giving guaranteed maintenance, and therefore basically to pamper your distributors, to educate your distributors so that they become more competitive, and the consumers are not attracted to buying goods from parallel importers. Rather, they buy goods from authorized distributors. Price interference is another possible strategy which could be adopted to combat parallel importation. Here again, it really, and a lot of these examples which I have given may not really fit for all the factual circumstances, and therefore it may come with a lot of caveats. But I think these are some of the strategies which have been successfully adopted. For example, Swatch watches have adopted this strategy where they interfere with the supply and they interfere with the market demand and thereby reduce the price and bring the parallel importer out of the market. Again, this is a related policy, adopting a policy which is of aggressive pricing, where original manufacturer initially offers the products at a lower price than that of the price which is anticipated of the parallel importer. Chanel has, for example, adopted this policy in order to restore some of its market share. Invest in effective market information system and alert system to warn of the parallel importers and the evil effects of that. The next condition which I have discussed here is, I think, very, very important, which is placing strict contractual obligations on your authorized distributors within the different territories in which they operate. Basically to say that the goods which are going to be distributed to your authorized distributors are not meant for export beyond that particular country. And you build in that limitation by way of a contractual agreement. You can also have, obviously, termination rights if there is a violation or termination of that agreement by the exclusive distributor. A lot of times, even a threat of termination or actual termination may result in the authorized distributor not really indulging in parallel importation. Some of the last condition which I want to discuss is, again, greater advertisement campaigns, effectively communication with consumers in order to basically warn them about the evil effects of parallel importation, and I guess canvass the reliability and trustworthy services of the authorized dealers. That's about it. Thank you.
Thank you.